the law Halawali. My name is Emmanuel Halawali. I'm an attorney, an author, a podcaster, and also a journalist. I have with me today Mr. Andy Miller. He's currently the assistant city attorney for the city of Columbus. He's a former law professor and is also a candidate for judge in Franklin County, Ohio. Andy, can you please introduce yourself to our audience?
Hi, everybody. Like you heard, Andy Miller. I am running for judge on the Franklin County Court of Appeals General Division, and hoping to have a good conversation today.
Oh yeah, so looking forward to that. Yeah, this week, last week we have an historical ruling from the Supreme Court. In the case of Woodstock, the court ruled that lesbian, gays, transsexual, queer, LGBTQ people uh, can file a claim and actually prevail under Title VII of the Civil Rights Act. We have three plaintiffs in that case. One of them was terminated because they participated in a gay softball team. Another one came forward and told her employer that she's actually um, some she's actually a woman when she's been passing herself around as a man, and because of that, she was fired. Ultimately, these people filed a lawsuit. It made it up to the Supreme Court, and we had a ruling last week. So, what do you think about that ruling from the Supreme Court? And what do you think this ruling will do to employers, employees, especially people within the gay community? How do you think this ruling will affect people in that category going forward?
Well, I think by the nature of the question, it's broad-reaching implications for a lot. My first inclination upon hearing the ruling, I had to be honest, was surprise. This has been a more conservative court, and people have been watching it fairly closely on what it was going to decide, particularly in these issues. And the way this issue was framed as it went to the court, there's different ways to look at litigation. And then there's the news, the layman's angle of litigation, and then there's the lawyer's angle. And what was incredibly interesting about the way this case came about was it was a very clever argument by a set of plaintiffs saying that the anti-discrimination statute was already in place, and that because it barred discrimination on the basis of sex or gender, that all of these issues, LGBTQIA issues, transgender issues, sexual orientation issues, they all end up being focused in the first place on sex and what it be, are also included. So usually in the past, it's been an effort by LGBTQIA activists to strike down laws that already exist. And this was an interesting situation because it was a group taking a law that existed and said, we're included within that in the plain language of it. And that was really the surprise to me, because I don't think anybody missed the fact that in 1964, when Title VII was passed, nobody was contemplating transgender or sexual orientation issues. However, 1964. Sorry, I was getting a little bit of feedback there. But Gorsuch's opinion focuses on the plain, ordinary meaning of the language, and he really came up with a solid argument that, regardless of the intent was, we have to go with what the language is.
Correct.
And therefore, the folks in these communities, because they're being treated differently on the basis of sex, it's not just sexual orientation, it's not just the root of all those distinctions, come back to sex. that they're included. As far as employers, because I'm a broad question, so I don't want to just keep talking, but as far as employers, I think a lot of them, by and large, at least the large scale employers, have been asking for this. I haven't been following, but I always thought and I don't want to speak for them, but I always thought the position of the various chambers of commerce have been pushing this sort of protection for it. And I know some of the larger employers in the state have been offering it that sort of protection as a matter of their own human resources. Mm-hmm. But as far as, and I'm not personally a member of the LGBTQIA community, so I can't honestly say how it would affect the psyche of those folks, but to literally have the Supreme Court saying, you're protected, another thing, acknowledging your humanity.
Yeah.
That's got a tremendous for well-being.
Yeah. What is interesting is that the dissenters, argue that being gay or being transgender or being lesbian doesn't qualify under the Title VII distinction that they are sex. So the question is, they wanted to have, they were arguing that the intent of that statute wasn't meant to cover people in that category. But then, if you look at that argument on a large scale, if you look at it broadly, if you apply it to other cases the court has decided in the past, most of the current civil rights that a lot of people have, even when we even consider the Constitution itself, if you look at the strict construction of languages, most of those rights will not have been available. And the court will not have been able to grant that right. If you were before that court, or if you are a member of that court, how would you have looked at this case? Will you have gone with those who wanted the strict language of the text of the Civil Rights Act, or will you have argued on the side of the majority who stretch the language to cover LGBTQ people?
Well, and I think the way you frame the question is interesting because, we all have a sense of, the position of the courts and the judiciary. And I don't think, I wouldn't have approached it, and I'd like to think judges don't approach it as, what outcome do you want to reach? They would approach it from which is the more intellectually honest argument. And what makes this particular case interesting is, obviously I'm not going to be so naive, at least some element of politicization going on in the judiciary, and that we all, have wondered about a new conservative court under Roberts. But it really, to me, it broke down when you look at Gorsuch's opinion and you look at Roberts. Yes. It almost comes down to judicial philosophy. I don't think there was any dispute, anybody, even the plaintiff supporters, that there was no way Congress in 1964 intended this to cover, in addition to just gender discrimination on the basis of sexual orientation or transgender identity. However, so if you're taking a pure intentionalist, what did the 1964 Congress really mean? Then you come out with the dissenters in this case. But if you take a textualist point of view, forget what the way we're allowed to look at what they meant is to look at what they said. And there's no reason to look beyond that. If it's clear, and the language was clear here, you're taking a strict textualist point of view. And from an academic honesty point of view, they were very close arguments. So I was extremely, given that, reasonable minds could differ on which is the best way to approach a statute, that they ultimately came out on the side that they did. As a judge, I tend to be more of a formalist. So obviously, personally, and judges are allowed to have personal opinions. I'm personally, know, LGBTQIA rights and treatment of all individuals as human beings, in a sense, and human rights. But I wouldn't approach the case from that I want to end up. I've always been very leery of result-oriented thinking. I want to get to a result, so I'll come up with a logic to get there. I would start with, I'm a formalist. The text of statute controls, and I think, of those two arguments, the Gorsuch's argument that no matter what the legislature may have intended, the text is what it is, the only logical way to apply it.
Yeah.
So I mean, if we're guessing, if I were sitting with that decision, I probably would have ended up on the majority.
Yeah, and if one looks at both arguments, if you want to go with the dissenters, and then what they're basically telling the court to do is to kick the can down the road and have Congress enact a new rule or a new act that will now cover LGBTQ people. Because if you read the dissents too, they're not saying that they should not be protected. They're just saying that it should not be covered under the Civil Rights Act. But then if you look at how the society is now, it should be. I don't think that would have been, well, it could be legally justified, but I don't think that would have been right. What do you think?
There's merit to the argument. Well, there's merit at legislative intent. The whole purpose of looking at legislative intent, because the legislators are our elected representatives, and their intent is really what governs. Problem is, in my view, from a judicial philosophy point of view, if you start deviating from the plain language of the statute because what you're guessing the actual intent of the legislature was, not the words they chose, because let's say in this particular example, the words they chose lead logically to one conclusion. Looking at their intent in contradiction of the words, despite the words, lead to another conclusion. You're almost inviting the very thing that people hate the most, which is judicial activism. So, having a strict guide for a judge's decision and being very clear that it's the language of the statute itself and the plain, ordinary meaning of words is how judges guard their power. They have a tremendous amount of power when it comes to interpreting statutes and judicial review. And I think, at least, I've clerked for 2 judges. I've also externed for Chief Justice Thomas Moyer when I was in law school. And one thing I've noticed about every judge I've ever run into, they really do guard themselves for overreach. The judges that I've admired take themselves very seriously, that they are their check on them. It's I think that's why I go with the textualist argument rather than the intent argument. The intent argument creates too much of a chance to insert your own beliefs into a decision.
You're right, because the reality is that when you can't bring the people that actually formulated our law to come and testify, and you can only read the notes from how the act was created. So no matter what you do, you're only trying to reconstruct what happened, and you never know, you might get it wrong. So moving forward, there are going to be some organizations, some religious bodies that will come up in opposition to this ruling, saying that, based on my religious beliefs, based on what our scriptures say, we can't hire gay people. We can't retain gay people because it goes against our belief. What do you have to say to people like that?
Well, again, that's a tricky one because now we're talking about policy going forward, and
Yes.
judicial candidates and judges alike have to be guarded against what they're advocating. I would say from the point of view I'm allowed to speak or I should speak, it should be solely on the what's available. This was a decision interpreted Title VII, the Civil Rights Act statute. It wasn't a constitutional decision. So statutes can be changed. If there's a group that thinks this decision was incorrectly decided and that the law shouldn't be the way the court interpreted it to be, they avail themselves of their congressmen and women, theirs, and see if they can get Title VII of the Civil Rights Act changed. In this political environment, I just don't see that magnitude happening. But that would be really the way it would have to go. I would really be disheartened if somebody said, "Well, we're just going to keep arguing it in the courts." The idea of supremacy and final judgment is, stare decisis is, we've dealt with this issue now. Let's move on. So the only way it'll change is if the statute changes. The only way the statute changes, Congress and the Senate change it. So yeah, I mean, whether somebody should try to do that or not, I'll leave that for the policy folks to argue. And I'm running for judge. My job isn't to make law; it's to try to make sure it's applied well.
Yeah, because going forward, people are disgruntled with the outcome based on religious reasons might want to, let me violate this law so that I have standing to file another lawsuit and hopefully to make it to the Supreme Court so that they can argue that they need some religious exemptions. So I know you can't speculate how that is going to happen, but we've seen that happen in situations like Roe v. Wade, that states keeps creating laws that on its face itself is against the law. But the point is they're trying to get to the Supreme Court to see if there's going to be a way to overturn that ruling.
Well, we're actually seeing it already because, Bostick, like I said, was a decision finally about Title VII, which is a federal law. There have been several states that have passed LGBTQIA protections as part of their own anti-discrimination laws. And those claims to religious exemptions or religious defenses to violations, they're already in the court system and working their way up. This adds a bit of flavor to it because it either removes or tweaks federalism arguments, but then that's that gets into the academic weeds. But the overall premise of what you're talking about, religious exemptions, claiming religious freedom in face of these anti-discrimination statutes, at least from the state level, state laws, that's been under the works.
Okay. Yeah, and if you look at how the court has leaned in at least this current court, at least for the past 10 years, the court has been leaning more to the progressive side when it comes to social issues. With is it Obergefell 5 years ago? We had Lawrence about 10 years ago. But then every 4 years or every 2 years, we still have elections, either general or local elections of people campaigning on these social issues, where they hope that if you elect me or if you elect us, we are likely to get Roe v. Wade overturned. Because most of the arguments against LGBTQ rights, most of the people against it are also people that are advocating to overturn Roe v. Wade. Do you think this should put that social argument to rest? Do you think this could do that? Or do you think it's going to fire up the opposition to the advancement of civil rights and the expansion of the same?
It's actually always very hard to tell how somebody's going to react to a decision. So, way back when, and I'm sorry, I realized that I used to teach law. One of the courses I taught was American legal history. So if I slip into that professor mode, it's because that's where I'm coming from. But way back when Roe v. Wade was originally decided, a lot of people thought that was going to be the end of the discussion, and no one foresaw the decades-long, wedge issue that abortion rights was going to be. I mean, if I were reading the tea leaves, I don't see I see this being more finite as a society. It feels like we've become more accepting of LGBTQIA. Um, yeah, so I think it's separate and apart. I think abortion is an issue that fires people up extremely on either side of the debate, and I think that explains more of its longevity. I think when it comes to LGBTQIA issues, it's as the concept is, and obviously gender and people of different sexual orientations or preferences, and questions of gender identity, they've been with us throughout history, no matter how much we like pretend otherwise. So the discussion about them is new, but relatively new. And it's just become more accepted. I don't see the same sort of pushback. I think if we were going to see it, we would have seen it with, oh, and I always butcher this name, and I apologize to the man. Oakville.
Obergefell, yes,
That
Obergefell.
decision about
Probably
5 years ago. I thought, yeah, if things were going to blow up from a social point of view, extremely angry, I thought would have been there. So this is almost just like other shoes falling, and it's just sort of bringing the LGBTQIA community up to the same level of protection that other marginalized minorities have
Yeah, and that's correct. And the good news for the community is that it's actually 50 years this week since the first Pride celebration. So it's a great
enjoyed.
yes, it's a great testimony to the movement. Let's talk about your candidacy. What makes you decide to run for office?
Well, I'm going to run for judge basically because it's my two passions in this world. Uh, I started law school back in 1998, and from the day I walked into Ohio State, I was just a nerd. I loved law. I loved everything about it. Um, to me, it's like a practical philosophy. It wasn't just about finding a profession, something I could do to make a living. It was about trying to find something I could do to make my working life worthwhile to others. And I always viewed it as it's sort of the law is the group that keeps the society moving. It's a philosophy because it's how we all treat each other. It's rules about what's best practices for our contracts or how we drive or how our government relates to us, how we organize. And so, in my career, I've followed. I've been the professor. I've clerked for judges. I've done the big law. And every time, it's always just been a new fascinating aspect of the law. So I love the law, and it's strange to love a concept that much, but I'm a dork. I'm a legal nerd. I spend a great deal of time with the sort of the heady, nuanced issues.
Mhm.
And then, so the last 10 years being with attorneys, I've also developed a real sense of pride in public service. This idea that not only am I practicing the law, which I think is a good profession for society, but I'm literally spending every day going to work in service to all. And there's just a pride in that. There's an honor in knowing that your time and your toil is being spent for, the greater public good. And, when you put those two together, public service and a love of the law, becoming a judge just seems almost an inevitability. I've got to give it a shot. I've got to, make my best qualified to do the job well. Definitely have the heart to do it. I want to do the greatest amount of good for the greatest number of. And I'm always conscious of the responsibility of public service. But yeah, it's almost like I feel like I wouldn't be giving to the society if I didn't do this, if I didn't try this,
Mhm.
if I didn't let them give me an opportunity to serve in this.
Mhm. So to you, it's more like public service, correct? So do you have
It is because go ahead.
like prospective judicial philosophy that if you were to become a judge, this is the kind of judge you hope to be.
Yes. Honestly, it's the way I've gotten through my career thus far. It's judges, when you come to a judge, judges, we do what they do. And for a lot of people, it gets lost. At the end of the day, the judge is basically there to make sure, a number of cases move through the docket in a thorough and efficient way. But for everybody who's coming in front of the judge, their only concern is their case. So from
Right.
their point of view, the judge is there to officiate their particular matter. I just view it this way. As a litigant, as a judicial clerk, I always ask the first question: what am I asking the judge to do? So as a judge, I'll be like, what am I being asked to do? It's a motion, it's an objection, it's a ruling. Judges are basically, they answer questions in a very binary way: granted, dismissed, granted, denied, dismissed, overruled, sustained. It's one or the other. So you ask yourself, you define the issue. What am I being asked to do? What are the rules? What gives me the authority to do it? And then what are the rules that govern the decision by which I, exercise that authority? And I would say the day-to-day issues that run across the trial judges, uh, 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 docket, or the ones they're faced with on a daily basis, are going to be pretty easily solvable by the existing legal rules. Now, judges, even trial judges and appellate judges for sure, get those new novel issues. And that is where you really have to then dig deep into the existing legal realm, the rules and what exists and what's out there in the case law, up with not just what you think is the correct solution, but the correct solution that you're allowed. Whose decision is it? Is it mine? Is it someone else's? Is it executive? Is it the legislature? So I would argue that I'm probably what you would call a formalist, because I think that's the way to keep you. It's very hard. Nobody will ever, and anybody who tells you it's easy to separate personal motivations, personal beliefs, personal opinions, and completely remove them from your mind, that would be that should be a daily battle.
Yeah.
And I think following more of a formalistic approach way to do it, give you a leg up in that fight.
Yeah.
Now, not to keep rambling, because I will, but the next one is one thing I've looked at with judges and that I would like to do is be accessible. Make sure that the litigants know that they can come and discuss matters with me to make sure things are moving smoothly. As much as I might be a formalist when it comes to procedure, there is unnecessarily formalist. Make sure people just speak respectfully with one another. I think that's another place I'd like to insert myself. Make sure that I treat the litigants in front of me with respect, and that they treat each other with respect too. Tensions run high in litigation.
Yeah. It's always nice to be nice. Do you want to tell our audience the court that you're running for exactly?
Yes, I am running for the Franklin County Court of Common Pleas General Division. And so it's a trial position, meaning that it's a court of what we would call original jurisdiction. All major civil litigation and all felonies as a matter of course to the trial judge first, Court of Common Pleas. And that would be the case. There are currently, I believe, 13 judicial seats. I'm running for one of them.
Okay. And if people wants to reach out to you, maybe volunteer or give to your campaign, how can they reach you?
I would appreciate anybody can reach me at andymiller4judge.com. ANDYFOR, Andy Miller, ANDYMILLERFORJUDJE at DGE at .com. Ugh, I can't write say words anymore.
Thank you, Andy, for
AndyMillerForJudge.com.
Okay. AndyMillerforJudge.com if you want to reach out to Andy Miller. He's running for judge of the Court of Common Pleas, Franklin County, Ohio. Thank you for coming on this afternoon. It was nice having this conversation with you, and have a lovely day.
I appreciate it. Have a good day.
Thank you too. Thank you for tuning in to Legal Angle with Emmanuel the Law Holowale. We'll be back in a few minutes with my next guest. Jake Mallory is a prosecutor, and we'll be talking about police reform. Thank you.